Welcome to another episode of Evershed Sutherland's Global Guide to Freezing Orders. I'm Will O'Brien. I head up our international commercial arbitration practice as well as cross-border litigation. I'm joined by my colleague Sheena Buddhdev. Sheena?
Sure. Hi, everyone. My name is Sheena Buddhdev. I'm a partner in the Litigation and Disputes Management team in London. My practice focuses on complex and cross-border disputes, both litigation and arbitration, and often with a civil fraud element.
And so today we're going to focus on two markets, the United Kingdom and the US, both very common markets to seek and obtain freezing orders, prejudgment attachments. We, of course, operate globally, but I think these are two good jurisdictions to study in terms of how one goes about getting this tool in place. So, Sheena, may I ask you, what's the legal test for a freezing order in England and Wales?
Freezing orders are exceptional in the English legal system because they involve far-reaching interference with the defendant's property rights and rights to privacy. And these freezing orders are often being sought at a time when the defendant or the respondent doesn't even know about the claim, or in many instances before the claim has been established at trial.
Well, may I ask you on that, Sheena, so when you say that the target, if you will, wouldn't know about it, is it possible to apply for these then on an ex parte basis, or must you always give notice, or what are the standards around that?
Yeah, let me take you through the process. Absolutely. Ordinarily, you're going to be applying for a freezing order on an ex parte basis. You don't want to tip off that respondent or defendant because you want to ensure that those assets aren't dissipated. So in 9 out of 10 circumstances before the English courts, you're going to be doing this on an ex parte basis. Let me take you through the test then. So in order to obtain a freezing order, through jurisprudence, the test has been established. Firstly, the court needs to have jurisdiction to hear a substantive claim against the respondent in England and Wales, or a statutory power to grant the order. And for example, the court has the power to grant interim relief in support of foreign court proceedings or arbitration proceedings. And we can come back to that, but this is going to be really important for many clients. The second part of the test is that there is proof that the respondent might try to hide or dissipate their assets. And again, this is going to be critically important for the English court. The English court has to have before it cogent and credible evidence that there is going to be a risk of dissipation. The court has to be satisfied that the order is fair and appropriate in all the circumstances, and importantly, that the claimant or claimants have a good arguable case against the respondent. Now, what does good arguable case mean? There have been multiple court decisions, especially recently, as to what this really means, and rather helpfully, during the summer, the Court of Appeal in the case of Dos Santos and Unitel provided some clarity on what good arguable case means. And what it really means, and I'm going to quote, it's more than barely capable of serious argument, but not necessarily one which has a better than 50% chance of success. So that bar is relatively low, and the rationale for that is that the court is put in quite an invidious position because it is deciding whether to grant a freezing order at a very early stage of the proceedings, at which point it doesn't have the benefit of arguments from both parties, so it can't decide what the better of the argument is, and therefore it set this bar relatively low.
What's interesting, if I may, Sheena, on that,
Yeah.
the notion that it doesn't necessarily have to be, if I'm hearing you correctly, better than 50%. We'll say, I think in the US, we face a more stringent standard. And again, when we're thinking about the overall jurisdictions in which to launch, when you're thinking about global asset recovery, this is perhaps why you might be in a more favorable jurisdiction in that sense, because in the United States, there are a lot of similarities in terms of a credible case that the assets will be dissipated or encumbered or improperly moved because of the anticipation of the judgment. But the standard here would be in that pending cause of action proving the likelihood of the success on the merits. So I feel that that's a stronger standard and a more difficult one to meet in the United States. I mean, I think in all of these jurisdictions, I believe the courts loathe to tie up monies because most places we want the money to be flying freely and flowing freely on spending to boost the economy. So courts are really reluctant to, in anticipation of, or rather before the conclusion of a case, to tie up monies. So that's why I think in both of our jurisdictions, you do have this fairly stringent standard, but it sounds like you might be in a slightly better position in your jurisdiction.
Maybe there is a slight distinction between the position of the US courts and the UK courts, because the UK courts and jurisprudence has shown this, is that they want to ensure that justice is served. And if a claimant is bringing proceedings and you have a defendant or a fraudster who's going to dissipate those assets, the court is going to ensure that the claimant is protected. So maybe there is a slight distinction there.
I should also mention that a big distinction between our jurisdictions would be that in the United States, of course, we have this system of the federal and the state, and in the prejudgment attachment scenario, that is governed by state law. So it's critical that when one is seeking to attach assets in the United States, that they have very local advice and practice, because it does vary dramatically from state to state. So that's always going to be an important consideration when you're thinking about filing in the United States. We'll also say that you had mentioned at the outset that there is the ability to go in ex parte without notice to the other side. And of course, in a case such as this, where you're trying to attach assets, that would always be preferable. That is available in many states in the United States as well as an option. Although as a practical matter, I will say it's important to follow up fairly quickly with notice, because most courts will want to ensure that the due process rights of the defendant would be absolutely honored. And so even though you have that initial ex parte, there are stringent notice requirements after that initial proceeding in most places.
And that's exactly the same in before the English courts as well. And an important point that I should make, and I think clients find quite hard to get their head around when they're seeking an ex parte injunction, is the duty to give full and frank disclosure when making an ex parte application. Is that something that exists in the US, Will?
No, it doesn't. And I've, in support of arbitration awards that we've obtained, that we are then enforcing and doing asset attachment within the United Kingdom, I've had to do the affidavits on the full and frank disclosure. There's really nothing akin to that in the United States system. It was quite a thorough exercise. And
Yeah.
I wonder if you can tell a bit more about it. What is the reason for the full and frank disclosure? And it's curious in a sense that it doesn't exist in the United States.
Yeah, and I think it goes back to the point I made earlier, which is a freezing order is an onerous order on the defendant, and it can interfere with rights. So what the court wishes to have before it, before determining whether to grant that order, is all material facts that are relevant to the granting of the order. And
And
this
that
is
is both strengths and weaknesses. Is that fair to say, or that
That's exactly
all rights?
it.
Yeah.
Naturally, you're going to put all your best points forward, but what the court expects you to do is also to put the counter arguments. So the matters that are relevant to the arguments that the court is hearing, that the applicant expects the respondent to make when they're both before the court in a few days or few weeks' time. So it is an onerous task, and the reason why it is so important is if you don't comply with a duty of full and frank disclosure, the respondent has potential grounds to discharge that order or have it lifted. And not just when you're both before the court, but further down the line, if in a few months' time ultimately facts come to light that prove that you did not disclose all of the information to the court that you should have at the outset, the respondent can go back to court and seek to discharge or vary that order.
Yeah, I remember when I was the declarant in the statement that I had to give in support of our client's arbitration award. The advice I got, it was akin to that it's not the crime, it's the cover up. You know, that if you're withholding information, that you really it's always good to err on the side of absolute disclosure as opposed to something that can come back and sting you later, even if that fact is not terribly material. Just that it was not disclosed is in and of itself, a weakness. Is that? Would you agree with that characterization?
Absolutely. You don't, as you said, you don't want to, within a few months of getting your order or weeks, find that there is a material fact that you didn't disclose and your freezing order's gone. Yeah, absolutely. Entirely agree with
Well,
that.
I wonder, just again on the point of when you're in the U.S. market, understanding the differences. One concrete example in the state of Pennsylvania, prejudgment attachment is not a tool that's available. So naturally, it gives you a sense, Sheena, of the importance of knowing your market and knowing exactly where you should be
Absolutely.
pursuing the claim. So May I ask you, in the United Kingdom, what type of assets can be frozen?
Every asset possible, Will. Bank accounts, shares, land, property, yachts, aircrafts, any asset. And it can be assets that are situated within England and Wales, and that's known as a domestic freezing order, or it can even extend to assets situated outside of the jurisdiction or worldwide. And I think we're all familiar with the term worldwide freezing order.
May I ask you, Sheena, it's not common for courts around the world to enter order attachments or freezing orders over assets outside of the jurisdiction, at least in my experience. You can tell me if you have a different experience. I'm just curious if you could tell us from your perspective, from your jurisdiction, what is possible.
Do you know, I always think the worldwide freezing order is one of the greatest weapons that the English court has in its arsenal. And actually, and I agree with you, Will, I think it's a really unique power worldwide and particularly powerful in the world that we live in now, when defendants, fraudsters will often move assets between jurisdiction to evade claims and arbitration proceedings. Absolutely.
Well, I think from my perspective, one of the reasons that's important is because, again, if you go back to this concept of there are many tools available when you're doing global asset recovery, I would add to that, I believe strongly that it's important to have a very coordinated strategy, and so that you're not taking inconsistent legal positions in one jurisdiction over the other, if you will. It's more of a one voice approach, one position approach. And I'm wondering if that ties in at all when you're talking about freezing orders on a worldwide basis.
Absolutely. You need that holistic strategy, and the court will grant a worldwide freezing order. But if the applicant wishes to enforce that order outside England and Wales, it will need the English court's permission first, and that is critical. So, from a lawyer's perspective, you need to be quite strategic. If there is a jurisdiction where there are assets, but you obtain local advice and you know that freezing order is not going to be enforceable in that jurisdiction, then there is no point seeking the court's permission to enforce that order in that jurisdiction. So, as you said, you need to be very strategic. You need this sort of holistic strategy right from the outset, or that strategy may change, Will. As we all know, as the proceedings continue, things change, defendants act differently, start to do different things. So, you've got to keep an eye on what they're doing with the benefit of other tools, and change that strategy as you go along. But in my experience, there is a distinction between common law jurisdictions and civil law jurisdictions. Often in common law jurisdictions, you are going to be able to enforce that freezing order, but more often than not in civil jurisdictions, you're not going to be able to. So getting that advice up front will serve your client's needs. Absolutely.